Hello, my name is Barry Arrington. I'm the Chief Legal Counsel for the National Association for Gun Rights. And today, in the next couple of episodes, we're going to be talking about legal worldviews. And I see eyes glazing over already. What does this have to do with the Second Amendment? What does it have to do with the right to keep and bear arms? And I'm here to tell you, it has everything to do with the Second Amendment. It has everything to do with the right to keep and bear arms, because your view of the basis of rights and where they come from and how they're applied today influences your view of the Constitution, of the common law, of law generally. And if you have these radically different worldviews, where one side says that morality, law, they don't really exist as concepts, and the other side says, well, no, morality is a real thing, and law is based upon that, where you're going to actually have radically different views of how to come out on these constitutional questions. We'll talk about how Heller's view, which was based upon the existence of the right, the pre-existing right to keep and bear arms, influenced the outcome in that decision today. In our next episode, we'll talk about the competing view based upon the thought of Oliver Wendell Holmes. And then finally, we're going to wrap it up with the living Constitution, what it means, and how we should shudder every time we hear that phrase. So today, the legal worldview that underlines Heller. So you'll notice that the two opinions in Heller, primarily Justice Scalia's majority opinion and Justice Breyer's dissenting opinion, took a radically different view of the Second Amendment. And so a lot of people think, well, how could two judges operating in good faith take such radically different views of the same text? How is that even possible? What I hope to explain to you in today's episode and the next couple of days' episodes is that it is not necessarily a matter of bad faith on the part of Justice Breyer. It is a matter of a radically different worldview. So what is the worldview that underlies Heller? One of the things that it does is it says that it has always been widely recognized that the Second Amendment, like the First and Fourth Amendments, codified a pre-existing right. The key text there is pre-existing right. What does that even mean? What it meant was that the Second Amendment, under Heller's worldview, doesn't create the right to keep and bear arms. It codifies a right that already exists, a pre-existing right. Well, that leads to the question of, well, where did the pre-existing right come from? And the answer to that is very easy. It came from the English common law. And so you got to regress here. Well, where did the English common law come from? And Heller provides the answer to that as well. Blackstone's work constituted the preeminent authority on English law for the founding generation. That's key. That's critical. That's very, very important. Blackstone was the foundation upon which the English common law was built for the founding generation. And that means it was also the foundation upon which the common law for America was built. Well, keep in mind, the Americans thought of themselves as Englishmen all the way up to the time of the Revolution. And they incorporated wholesale the laws of England, including the English common law. After the Revolution, they did not have a radically different view of the law. They continued to incorporate the English common law, and Blackstone became the basis of the common law of America as it had been for England in prior years. The American Revolution was unlike the French Revolution in this respect. In the French Revolution, they decided we're going to have a radically different view of everything, including law and property and government and the church, or the non-church as it turned out to be. America had a very different view. It was a conservative revolution, if you will, and the founders incorporated wholesale the English common law, based primarily on Blackstone, into American law at the founding era, and Heller recognizes that. And so Heller recognizes that Blackstone had a profound influence upon the understanding of the right to keep and bear arms at the time of the Second Amendment was adopted. Well, what was Blackstone's view of the common law and of rights and the right to keep and bear arms generally? Here, we have to understand how Blackstone codified the common law. He said all of the common law is divided into three, what he termed absolute rights. And these absolute rights may be reduced to three principal or primary articles: the right of personal security, the right of personal liberty, and the right of private property. Now, if that sounds kind of familiar, it should. Let me read to you from the American Declaration of Independence. It says that all men are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. Sounds like we're kind of talking about the same thing, and indeed we are. Blackstone was influenced heavily by Locke, and so were the founders. And the principle that was being talked about here in the opening clauses of the Declaration of Independence are the exact same Lockean principles that Blackstone was alluding to in his commentaries. So where does that leave us? Well, we have to go on. What did Blackstone think about these three absolute rights? What does that have to do with the right to keep and bear arms? It doesn't say that the right to keep and bear arms is one of those absolute rights. Well, the next thing after establishing the absolute rights is what he called the auxiliary rights. So what are these auxiliary rights? We won't go into all of them, but there are five. And the fifth auxiliary right, according to Blackstone, and I quote, "The fifth and last auxiliary right of the subject that I shall at present mention is that of having arms for their defense." So the right to keep and bear arms goes all the way back to the English common law, and the English common law is built upon Blackstone. And what is Blackstone built on? If we want to go further back, what is the worldview that underlies Blackstone? And this is very interesting because it is a radically different worldview than lawyers and judges typically subscribe to today. So Blackstone says, "And consequently, as man depends absolutely upon his maker for everything, it is necessary that he should in all points conform to his maker's will. This will of his maker is called the law of nature. For as God, when he created matter and endured it with a principle of mobility, established certain rules for the perpetual direction of their motion," basically he's talking about Newton's laws of gravity there, right? "So when he created man and endured him with free will to conduct himself in all parts of life, he laid down certain immutable laws of human nature, whereby that free will is in some degree regulated and restrained, and gave him also the faculty of reason to discover the purport of those laws." Heller is based upon the pre-existing right to keep and bear arms. The pre-existing right to keep and bear arms is based on the English common law. The English common law, the foundation of that was Blackstone's commentaries. And the foundation of the foundation, if you will, is God's law, or as Blackstone would say, our duty to conform ourselves to our Maker's will. And how do we do that? What was the job of judges? For the first roughly half of the nation's history, the job of judges was seen as discovering the law in all of its important aspects. That doesn't mean that the moral law or the natural law has to do with every aspect of law. For example, the rate of taxation probably is not something that is subject to a immutable natural law. But murder, theft, the right to keep and bear arms, these are things that can be traced back to God's immutable natural law. Well, how does the right to keep and bear arms trace back to God's immutable natural law? What Blackstone said, one of those laws is the right to life and personal integrity of your person, basically. And how do you maintain the personal integrity of your person if the government is not standing there right beside you, willing to protect you at all times and against all threats? Well, Blackstone says that a natural ancillary or subsidiary view of the right to integrity of your person is the right to defend your person. And how can you defend your person if you don't have the right to keep and bear arms? Today, we've had a primer on jurisprudential worldviews and the worldview that our founders had in terms of law and natural rights, and the worldview that Heller is based upon when it says that the right to keep and bear arms is a pre-existing right. Well, what does that even mean? We talked about that. In our next episode, we'll talk about the opposing view. And the star of the next episode is going to be Oliver Wendell Holmes Jr. And we'll discuss, was he a hero, as the modern academy would have it? Or was he a villain, as many on the conservative right would say? Well, stick around. We'll find out. Thank you for tuning in.